So we start with the definition of what an obligation is. I think everybody knows the definition by heart. That's in Article 1156. Now, if you will notice, class, one important word that appears in the definition is the word juridical. Obligation is a juridical necessity to give, to do, or not to do. In the definition of what obligation is, the word juridical is very important. Why? Because that distinguishes a civil obligation from a natural obligation and from a moral obligation. If you will notice, if we remove the word juridical, it is just a necessity to give, to do, or not to do. Okay, it follows that in case there is non-performance of the obligation, then you cannot go to court and ask for specific performance. That is why, if you will be asked to define what is a civil obligation, do not forget the word juridical, necessity to give, to do, or not to do. Now, natural obligation, there is an enumeration of an example of what are natural obligations under the Civil Code. And what is a natural obligation is defined under Article 1423, wherein it is no longer a civil obligation, but out of voluntariness on the part of the debtor, he still performs it. Later on, debtor cannot anymore demand that it be given back, whatever he has given be returned to him. Why? Because the mere fact that he voluntarily performed an obligation that is not anymore a civil obligation, it now becomes under the definition of a natural obligation. I advise you to memorize the examples of what are natural obligations in the Civil Code. So that means if in case debtor has already performed, let us say, he already gave his payment, while in truth and in fact, legally, he does not anymore have the obligation to do it, he cannot anymore demand for the return. Why? Because it falls under natural obligation. Even if he goes to court, the court will not hear the case. Because in a natural obligation, the word juridical does not anymore exist. What about a moral obligation? It's the same thing. Similar to that of a natural obligation, in case there is non-performance of the obligation, you cannot go to court and file an action for specific performance. What are examples of moral obligation? From the point of view, let us say, of the Catholics, it is our moral obligation to hear Mass every Sunday. But I know that some of us do not religiously hear Mass every Sunday. But have you heard of any case wherein the parish priest files an action for specific performance? There is none. Why? Because although it is an obligation, it is simply a moral obligation. Now, what are the elements of an obligation? The elements of an obligation are, first, there should be the parties. Second, you have the object. And third, the sanction or the juridical tie. Now, when it comes to the parties, you have the active subject and the passive subject. Now, if you will be asked by the examiner, who is an active subject in an obligation? Is he the creditor or is he the debtor? The active subject refers to the creditor. The passive subject is the debtor. Now, you might ask, what is the reason why the creditor is considered as the active subject, while the debtor, the one who will perform the obligation, is the passive subject? The reason why the creditor is the active subject, it's because he is the one who has the right to go to court in case there is non-performance of the obligation by the debtor. So that makes him an active subject. Now, the object refers to the prestation. And the prestation is the conduct to be performed by the passive subject, the debtor. And what is that conduct to be performed by the passive subject or the debtor? Going back to the definition of what an obligation is under 1156, it refers to prestation to give, prestation to do, prestation not to do. So the prestation to give, the prestation to do, prestation not to do, this is what we call as object under obligations. But insofar as property is concerned, the word object there refers to what? To the property, to the thing. Tomorrow afternoon, when we take up contracts, one element of a valid contract is what? An object. The word object there has the same definition as that of the object in property. So be very careful about your terms. Now, take note, so that the obligation can be considered as valid, then the object as an element of the obligation should be determinate, it should be useful, it should be lawful, it should be accessible in money, and it is possible. So these are the qualities for an object to be valid. When we connect obligation with contracts, if the object is unlawful, then the contract will also be considered void. Now, and the last element is the juridical tie, the sanction. So that means in case there is non-performance, then you can go to court and file an action for specific performance. Now, there are different kinds of obligations. You have obligations according to the peculiarities of the prestation. And under this classification, you have the pure obligation, you have the obligation with a condition, obligation with a period. The next classification of an obligation is obligation according to number of parties. And under that, you have the joint obligation and the solidary obligation. The next classification of an obligation is according to prestations to be rendered or number of prestations. So earlier, the classification is about plurality of parties. Now, it is according to the number of prestations. So under that, you have the individual obligation. So that means there's only one prestation involved. And then you have the multiple obligation. And under that, you have the alternative obligation and the facultative obligation. Okay? And the last classification of an obligation is according to the quality of the object. Remember, class, we defined object as prestation. Diba? So it can be a positive or a negative obligation. It can be a specific or generic. Okay? It can be divisible or indivisible. Or it can be principal and accessory. Positive, that means you have to perform the obligation. Negative, you are prohibited. Okay? Specific, that means determinate the object here. So we are now turning into the definition of object as referring to the property. Specific means it's a determinate object. The other one, generic, it is an indeterminate object. And then divisible and indivisible, it refers to whether it can be performed partially or not. So if you say it is divisible, there can be partial performance of the obligation. Indivisible, it cannot be partially performed. Principal and accessory, this kind of an obligation will have to be connected now with contract, which is a source of an obligation. So, the obligation arising from the principal contract, that is the principal obligation. The obligation arising from the accessory contract, that is an accessory obligation. Best example, what can be a principal contract? Simple mutuum. So the obligation to pay, that is the principal obligation. What can be an example of an accessory contract? That simple mutuum will be supported or guaranteed by a pledge. So the obligation of the pledgor in the contract of pledge is an accessory obligation. The sources of an obligation, in my opinion, is very, very important because this will tell you that civil law embraces all of your law subjects. So I want you to remember by heart what are the different sources of an obligation as enumerated under Article 1157. By law, by contract, quasi-contract, delict, quasi-delict. Usually, students always connect obligation with contracts. Kaya, bakit nagkaganon? Kasi misleading yung title ng book, Obligations and Contracts lang. Hindi na niya sinabing obligations and law and contracts and quasi-contracts. Napakahaba nga naman. Pero kung titingnan mo, may special provision on quasi-delict. There's special provision on quasi-contract. So can you give me an example of an obligation that arises from law? Under the family code, what is an obligation? Example of an obligation that arises from law. Obligation to support. It is an example of an obligation arising from law. Payment of taxes. That is an obligation arising from law. Now, quasi-contracts. What is negotiorum gestio? And why is it considered as a quasi-contract? The reason why it is a quasi-contract class, because here the parties do not have a meeting of the minds. There was no consent between the parties, and yet, because one benefited out of the act of another person, therefore, the person who was able to gain benefit has the obligation to pay for damages. And in negotiorum gestio, this refers to what? Managing the property of another person. And that act of managing the property of another person is without the consent of the owner of the property. And if by that act of managing the property, he was able to save the property, therefore the owner of that property has the obligation to pay damages. Negotiorum gestio. Best example of this is usually when a house is on fire. So, diba, kung yung kapitbahay mo, nasusunog ang bahay, naawa ka, sinagip mo kahit hindi ka tinatawag, that act is tantamount to what? Negotiorum gestio. Remember what happened when there was Typhoon Ondoy in the Philippines. Diba? Makita mo sino yung mga artista na pumunta sa sa Antipolo at saka saan? Ano ba yung Marikina? Dito sa E. Rodriguez, sa Aurora Boulevard, naging swimming pool yan. So, sino yung mga nagpunta ron na kahit hindi nila kakilala, tumulong to be able to save properties of other people, the victims. Now, that is tantamount to negotiorum gestio. So, if something happened to them, then the owner of the property that was saved has the obligation to pay for damages, and that is an obligation arising from quasi-contract. Solutio in debiti, unjust enrichment. This is the principle of unjust enrichment is one of the things that you should not forget. Why? Because worst scenario, if you cannot remember the special law that will be used to answer a question in the bar exam, and there's a possibility of using this principle of unjust enrichment, you use it. So what is this solutio in debiti? Unjust enrichment. if you get something that does not lawfully belong to you at the expense of another person, that is tantamount to unjust enrichment. Solutio indebiti. That's why if you will recall in property, isn't it, there's a provision, Article 719, you are not a finder's keeper. If you discover something, okay, what should you do? If it does not belong to you, if it does not fall under the provision governing hidden treasure, you have the obligation to surrender it to the proper authority, and that proper authority has the obligation to what? Give notice that a property was discovered. It's only after the lapse of 6 months. If nobody would claim it, that's the time that you as finder will have the right to claim ownership over it. Because if you will immediately claim ownership over it, that will be tantamount to solutio indebiti, unjust enrichment. Can you file an independent civil action without making any reservation? You know, class, that is one of the questions that is usually being asked in the bar exam. But to be able to answer that, the sources of an obligation is the key to the answer. Going back this time, I want to connect you to Article 100 of the Revised Penal Code, as well as Section 1, Rule 111 of the Rules of Court. Pag tinanong yan sa bar exam class, ang sabi ko nga sa mga estudyante ko, always go back to the sources of an obligation. Law, contract, quasi-contract, delict, quasi-delict. Now, if you will remember, we go back again to your persons because it has something to do with the sources of an obligation. Articles 29, 30, 31, 35, and Articles 32, 33, 34, 21, 77. This one, you have to connect it with Article 100 of the Revised Penal Code and Section 1, Rule 111, Rules of Court. Why? If you will go back to Articles 29, 30, 31, and 35 of the Civil Code, class, these provisions refer to what? An obligation arising from a delict. And delict is one of the sources of an obligation. What provision in the Revised Penal Code confirms that? Article 100. What does Article 100 of the Revised Penal Code provides? A person who is criminally liable is civilly liable. So, if you heard before when FG filed a libel case, libel is a criminal case, isn't it? But in addition to the criminal case for libel, he was asking for damages in millions. So one single act, which is defined as a crime, will also give rise to what? Damages, civil obligation. And that is the reason why, under your rules of court, Section 1, Rule 111, if you file a criminal case, the civil case is deemed instituted. Very practical. Why? Because we're talking here of a civil liability arising from a delict. But then, that is not mandatory. That is simply a general rule. Because the same provision provides for exceptions. And what are the exceptions? Number 1, if the civil action was filed ahead of the criminal action. Number 2, if there is a waiver in filing a civil action. Number 3, which is an answer to our question, if there is a reservation in filing an independent civil action. So that means, if that question will be asked in the bar, can you file an independent civil action without making any reservation? If the problem does not mention what is the source of the obligation, you qualify. If the obligation arises from law, from contract, quasi-contract, quasi-delict, yes, I can file an independent civil action without making any reservation. But if the obligation arises from delict, in accordance with Section 1, Rule 111 of the Rules of Court, together with Article 100 of the Revised Penal Code, I have to make a reservation before I can file an independent civil action. That's why I told my students in class, if you will notice, this one belongs to one family. Magkakamag-anak sila. Samantalang ito naman, another family. Bakit? Pag binalikan mo yung 32, 33, 34, 21, 77, these are obligations arising from, it might be law, contract, quasi-contract, quasi-delict. So if the problem in the bar talks about 32, 33, 34, 21, 77. And the question is, can you file an independent civil action without making any reservation? What is your answer? Yes or no? It should be yes. Because it arises from other sources of an obligation, not from a delict. Reservation is only a requirement if you are talking of an obligation arising from a delict. Let me repeat, reservation to file an independent civil action is a requirement if you are talking of an obligation arising from a delict. But other sources of an obligation, you can file an independent civil action without making any reservation. Next question. When do you have to make the reservation to file an independent civil action if you are talking of a civil liability arising from a delict? You make the reservation before the prosecution presents evidence in the criminal case. You make the reservation in the criminal court before the prosecution presents evidence. So that means you make a manifestation. Your Honor, I would like to make a reservation in filing an independent civil action arising from this delict. Okay? Dapat pa bang itanong ko, halimbawa, ano nangyari pag namatay ang akusado? What happens to the civil liability if the accused died in the criminal case? Will the civil liability arising from the delict also be extinguished? We're talking here of a civil liability arising from a delict. Nagkataon na tigok yung akusado, inatake, bago basahan ng sentensya. And it really happened when I was in PAW. Pag namatay ba yung akusado, patay na yung civil liability niya? This time, remember the cases of Bayotas and Senday Diego. And what did the Supreme Court say? If the accused died, the civil liability arising from the delict is also extinguished. Because take note, under the revised penal code, the death of the accused will extinguish the criminal liability. But then, the Supreme Court further said that the victim or the relatives of the victim may still pursue the civil liability provided that it will now be based on the other sources of an obligation. And can that be possible? Yes. Why? Because remember, in your criminal law, an act can only be considered a crime if it is defined as a crime under the revised penal code or any special penal law. Now, among these sources, what can be an act which can at the same time be a delict? It cannot be arising from law. It cannot also be arising from a contract or a quasi-contract. So the only possible thing is it may arise from a quasi-delict. And in quasi-delict, what is one important element of a quasi-delict? Negligence. Now, is there any act or felony wherein there is an element of negligence, class? Yes. Reckless imprudence resulting to homicide or physical injury. So if the accused died and the crime charge is reckless imprudence resulting to homicide or serious physical injury, the civil liability arising from that delict is extinguished. But the victim or the relatives of the victim may still file a civil action for damages, but this time treating the act not as a delict but as a quasi-delict. Question. So who will now be the respondent? Patay na yung akusado. The estate of the accused. Remember in persons, in the case of Pedro Fragante versus Limhoco, Supreme Court declared the estate as a juridical person. Kaya nga diba sa mga civil cases, pag namatay, ang substitution, hindi mo sinasubstitute yung compulsory heirs. Ang isa-substitute mo yung estate ng defendant. Now, what is important here is that even if in one single act wherein negligence is involved, you can treat it as a quasi-delict or as a delict, and therefore, there is a civil liability arising from the delict and a civil liability arising from the quasi-delict. You have no right to file two cases for civil damages. Why? Because that will be tantamount to unjust enrichment. So if there is already a civil action that is deemed instituted in the criminal action and the accused did not die, okay, so you just pursue that. But you do not anymore have to file another civil action, this time treating the act as a quasi-delict. Because if you will do that, then that will be tantamount to double recovery and it is unjust enrichment against the accused. Now, quasi-delict, I have already mentioned to you, here there is an element of negligence. So basically, this is covered by torts and damages. Okay? That's why, again, let me repeat, these sources of an obligation is very, very helpful because it tells you that civil law encompasses everything.